welcome. This is the Petri Dish, and we host this once a month as a way to get appropriate topic in front of lab owners, executives, directors, scientists, and just create a forum for people to come and talk about what's new and what's happening in the industry, what questions they might have. And one of those questions that we get most frequently is on legal, regulatory, and compliance matters. So I wanted to host a special session on that just to give you an opportunity to hear from an expert and ask questions that you might have related to that. This session of the Petri Dish is being sponsored and co-hosted by UDoTest, and UDoTest specializes in assisting with direct-to-consumer, direct access testing, several other areas as well. We're going to let them talk a little bit more about what they do and have Allison introduce herself here in a minute. But we also have McDonald Hopkins on the line with us, and they'll be speaking from a professional regulatory standpoint, and they've got a bunch of experience doing that over 90 years, as you can see. So we're going to go ahead and get started here. This is going to be covering a variety of topics related to legal, regulatory, compliance. We're going to hit on FDA regulations as they relate to direct access testing, as well as how they relate to LDTs, lab developed tests. We'll hit a little bit on EKRA, Stark, Kickback. There's always questions about that. I know EKRA has been most recent, and there's still a lot of questions and not a lot of precedent there, but we'll have Elizabeth and Aaron give us their insight there. Direct access testing, consumer-initiated testing, there's a lot of different names for that. Direct-to-consumer testing, they're all a little bit different and nuanced, but we're going to cover that as well. We will hit on CLIA state and staffing requirements, what's required for staffing performing different levels of testing, and that from a federal and a state perspective. And then what's the difference between moderate and high complexity? All states don't even recognize those, but we'll go over a map that kind of gives you some guidance on it. But encourage you to go ahead and respond to that poll so we know where to focus our time. And we're going to go ahead and get into it. I'd like to introduce Allison Martin of UDoTest. She's the founder owner of UDoTest. And Allison, why don't you tell us a little bit about what you're doing there?
Yeah, thank you, John. It's an honor to be here today, and it's really great hosting these webinars with you once a month. So I'm excited about the session today, and to have Elizabeth and Aaron and our friends from McDonald Hopkins joining us today. So without further ado, very briefly on what it is, we know a lot of the people on the call today, and some of them are our clients already, but essentially a quick summary on what we've been doing for the past 3 years here in the United States is essentially UDoTest. Very briefly, as you know, we're a B2B at-home disease testing software platform, and our software is designed specifically for labs to reach more patients, offer physicians value, and increase revenue. And essentially, we've spent a lot of time and energy on essentially our software that is white labeled, it's HIPAA compliant, it's a patient engagement platform, along with the specialized interface that we serve national physician networks with. And it's a lab management system that can deliver personalized at-home testing experience into your patient's home. So very briefly, that's what we're up to, and very excited to grow that space across the United States and beyond. But without further ado, our very exciting talk today with McDonald Hopkins and introducing Elizabeth and Aaron Conway. Elizabeth is the co-chair of the firm's national healthcare practice. She has experience in providing regulatory, licensing, compliance, reimbursement, contractual, and corporate guidance to clients. She's advised clients on state professional licensure laws, CLIA standards, state lab laws, government and private payer reimbursement policies and billing rules, federal and state fraud and abuse laws and regulations, state telehealth laws, as well as HIPAA compliant rules and regulations. We're really excited to get Elizabeth on the line to advise all of us and to give you some deep insights. But along with Liz, we've also got Aaron, and Aaron has significant experience representing the clients of all sizes in the FDA regulated industries, including food, beverage, nutritional supplements, cosmetic, drug, and med device companies. And she understands the effects of the FDA and FTC compliance issues often have on IP strategy. So without further ado, let's hand over to them and dig deep into all the questions that you guys have been asking. Elizabeth, I'm handing it over to you. Thank you so much for joining.
Thanks, Allison. And thank you all for joining us today. So what Erin and I wanted to do, just to quickly kind of run through the agenda, is we're going to touch on a number of topics this afternoon, as you can see here from the agenda, and we're going to move pretty quickly based on the fact that we've got we're trying to do this over the lunch hour. So we are going to touch on everything at sort of a high level. We're hoping to have some time for questions at the end. We're happy to take any questions. And our hope is just to kind of introduce everybody to these issues if they're not familiar with them yet, or to talk a little bit about how we think they apply specifically sort of in this arena. So that's our sort of roadmap for this afternoon, and I'll go ahead and get started. So I'm going to talk about some of the regulatory issues on our agenda. So the first thing we wanted to do was speak briefly about the distinction sort of between direct access testing and consumer-initiated testing, at least as we see it and how we apply it. With respect to direct access testing, what we're really talking about there is something that's marketed directly to a consumer and something that a consumer can order directly without physician involvement. In most of these instances, or at least a lot of the workflows that we are approached about with respect to direct access testing, the consumer's physician or any physician may not necessarily receive the test results or the report from the lab. That's going to go right back to the consumer that had requested it. The interest in direct access testing continues to increase, certainly. That's why we're all on the phone today. And we're certainly getting more calls about it. But it is an interesting challenge, as we'll talk about a little bit more through these slides, because it sort of falls into its own space, or it falls into the traditional space of diagnostic testing under CLIA, and that framework doesn't fit all that well. So that's really what we're trying to focus on today. Many states do permit some form of direct access testing, but in many of those states, it has limitations. So we're going to talk about that a little bit more in a moment. So consumer-initiated testing, what we're talking about there, what we're thinking about when we say consumer-initiated testing is it is something that is marketed to the consumer, but the workflow as far as ordering the testing and sort of reviewing the test request, ordering the test, and then receiving the results before they go back to the patient, there is a physician involved in that workflow. So while the test will be marketed to the consumer, a physician or an authorized person, some type of clinician that it can order testing in that jurisdiction, is involved in the workflow to review the test order. Then the physician, or the clinician would place the order, and the results are going to be returned, at least to be looked at by the physician or the clinician. The physician or the clinician has the responsibility to release it to the consumer. And I think what's interesting when you contrast these two models is that in this model, it actually matters for purposes of the clinician that's involved or the physician. The State Medical Practice Act or the Appropriate Professional Practice Act that applies to that clinician is important, because it talks about how that individual or that professional is permitted to serve clients and when they would be authorized to order a test, or what types of tests would be acceptable, from a remote perspective versus actually seeing the patient in person. And so I think that's, a lot of what we're going to talk about today are kind of different things to think about and get everyone familiar with sort of issue spotting as you're working through a workflow or you're, developing something new. So there's a couple different elements here, but certainly on the consumer-initiated testing side, you have to sort of consider the relevant professional practice acts and sort of what is the scope of practice for the clinician or the physician that would be involved in the workflow. If there's a telemedicine statutory regulation or code of regulations or rules or something like that at a state level, you also have to be familiar with those. And so one of the things that's really important, whether we're talking about direct access testing or whether we're talking about consumer-initiated testing is, unfortunately, right now, there's not really a one-size-fits-all. It is sort of a state-by-state analysis because there's so many different moving parts that are relevant in the analysis. And just to kind of circle back or emphasize that, with respect to the regulation of direct access testing, right now, based on the research that we've done in the past, which has been it's sort of a rolling basis over the last couple of years because it's fairly time intensive. So this is probably a few years. I would say I feel pretty comfortable in some of these states, while others, it's been a few years since we've looked at them. There's about 36 states and the District of Columbia that permit some form of direct access testing. 14 states that we are aware of prohibit it. But again, as I noted in an earlier slide, states that permit direct access testing vary greatly. So some will limit it to certain tests, and that could be the type of testing, meaning it's testing for this type of issue, or this type of diagnosis, or it could be limited by this is a type of test that is actually FDA approved, or you have to have a test kit that's FDA approved to be able to offer it in our state. So states really do come in sort of all over the map with respect to what's permitted when they fall into that category of we do permit some direct access testing, but it's limited. Sometimes the test purposes are limited by, this is only educational, this is for health awareness, it doesn't actually provide a diagnosis. So then you kind of get into the gray area there, like, okay, well, what does that mean? What is the state going to consider to be a diagnosis versus this is just educational or this is wellness or what have you. Most of that information is in the state statutes and administrative codes. Sometimes it's silent, and that's where it gets really tough to kind of make a judgment call and analyze sort of the regulatory framework in a particular state. And it's just worth noting that in most states that allow direct access testing, they're also going to allow consumers to receive the results directly. That kind of goes hand in hand. And I'm going to kind of circle back to a couple of these themes when we talk about CLIA and a couple of the CLIA slides. Because it's all related, and that's kind of the challenge here is that you've got with direct access testing or consumer initiated testing, what you're doing is you're taking a couple different frameworks that have sort of traditional, frameworks and workflows, and you're knitting them together. And frankly, the regulatory landscape hasn't kept up with that, which is part of the reason that, there's a little bit of question, a little bit of play, within this arena. So with respect to analyzing out-of-state specimens, and this will be true, I will note this when we talk about the CLIA slides, even though direct access testing, it feels like a little bit of its own animal, and there may be situations where there's FDA approval, typically the testing still needs to be done, or frankly, it does need to be done by a CLIA certified laboratory. And so for a laboratory that's sitting in a particular state, the laboratory also needs to keep in mind state laws with respect to laboratory testing. So there are a number of states that require a laboratory to have a state license if located in the state. And this probably isn't a surprise to anybody on the call, but just to kind of make sure we're covering the waterfront of issues here. So states that have a state lab license, some of those states would be Washington, New Jersey, Pennsylvania. And in those instances, actually in Washington and New Jersey and Pennsylvania, I'll save for the next bullet point, Washington and New Jersey those are states that say if you have a lab in our state, you must have a lab license issued by our state. But they don't necessarily say that if you are accepting specimens from that state that you have to have a lab license. That said, there are some states that do require out-of-state laboratories to have a state license if they're accepting specimens from those states. So the ones that are sort of the common list of states that require out-of-state labs to have licenses are California, New York, Maryland, Rhode Island, and Pennsylvania. So accepting specimens from those states would require an out-of-state lab license. Some states even require a license if the lab is collecting in the state. So for example, New Jersey actually requires laboratories to obtain a New Jersey license if they are collecting if they have a collection station in the state. Again, this is a little bit outside of what I'm sure most of the people on the phone are doing or contemplating with a workflow, but just again, to try and get the full landscape. And then the last thing I would say is, although some states do require a license if the lab is collecting in the state, there are a number of states that don't govern the collection of specimens. And so one position that we have seen laboratories take recently, sort of in this world, and we're not talking so much about consumer initiated, right? Because in that instance, you've got a workflow that has a clinician involved. But on the other side, if we're talking about direct access testing that's going straight to the consumer, coming back to the lab and then going back to the consumer, some labs will they'll establish their lab in a state where direct access testing is permitted, and then they'll offer the testing to other states that don't govern the collection of specimens. You know, from my perspective, this is definitely an argument we've seen, and we've seen some models like this. You know, whether this is going to allow labs to avoid enforcement for direct access testing in jurisdictions where it wouldn't otherwise be permitted, I think that remains to be seen. I think it's one of those things that's just waiting for sort of a bad set of facts to bring this in front of a set of state regulators, and you know, maybe that would prompt some change with respect to the framework that says, hey, if you're collecting in our state, but you're not testing in our state and you're complying with your own state's requirements, then we're not going to do anything about it. I think it's the sort of thing that's going to take, you know, sort of like, well, okay, we've got one or two bad facts, and all of a sudden those regulators are sort of changing their tune. So moving on to talk a little bit about CLIA, and then I'm going to turn it over to my colleague Erin to talk a little bit more about the interplay between CLIA and the FDA, or I should say CMS and the FDA. I mean, CLIA is, and again, I'm guessing that everybody on the phone is pretty familiar with this, so I don't want to spend too much time on it, but the Clinical Laboratory Improvement Act of 1988 is sort of the regulations that flow from that are the regulations that govern clinical laboratories in sort of the traditional space. CLIA certificates are issued or sort of granted by CMS, although they can be obtained through a number of accreditation entities, including, you know, for example, the College of American Pathology or, you know, various state departments of health. But really what those regulations are focused on are the quality and the accuracy of the laboratory operations and testing. It has been our experience that CLIA does not distinguish between direct access testing and non-direct access testing. The idea is, you know, if it's being run and it meets the definition of you know, a type of testing under CLIA, then it's going to need to be run in a lab that is a CLIA certified lab. And I think, and then kind of to circle back, trying to weave these concepts together, the CLIA framework at a federal level says that all testing must be ordered by an authorized person, but the CLIA regulations or the CLIA framework doesn't define what is an authorized person. That is defined by state law, or, you know, some states it's silent, or it's sort of inferred through looking at the Professional Practice Acts and who may order a test. So, you know, again, kind of circling back to the concept of direct access testing, you know, CLIA is sort of at the top and sort of overlays all of the clinical lab operations. And then, you know, as you drill down, you realize, okay, well, authorized person is something that has been left to the states to define. which again sort of underscores the idea that it's a state-by-state analysis in many instances. Okay, so I threw up the CLIA definition of laboratory, and part of the reason I think this is relevant is just to go back to the idea of, okay, when we're talking about direct access testing, what exactly is sort of in scope and what is not, and what might be permitted and what would be outside of the traditional laboratory, framework. And I think if you read this, and again, probably everybody on the phone is pretty familiar with this definition, you know, it's pretty broad. It doesn't leave a lot to sort of be, well, these test results are, you know, they don't relate to diagnosis, they don't relate to prevention, they don't relate to the treatment of any disease or impairment of, or the assessment of health of human beings. So I think when you think about it that way, we are working with a framework that is fairly broad. So in that respect, I think it just underscores the idea that it's very important to be familiar with your particular state as well as the federal sort of overarching regulations. And one thing that I have not talked about much yet, or actually I haven't mentioned yet, and that's partially because, you know, as I've understood it, sort of the audience that we have today is mostly interested in direct access testing or consumer-initiated testing, and we're really talking about situations where we're not looking at reimbursement from commercial insurance or from government insurance. Rather, we're sort of focused on cash pay, and so I think that actually is relevant because I don't talk a lot in here about reimbursement, because if we're talking about payer reimbursement, then that kind of adds a new level of scrutiny and some additional requirements that would need to be met. And I think that, you know, that's almost a separate discussion in and of itself. So with that, I am actually going to turn it over to my colleague, Erin, to talk a little bit about the interplay between the FDA and CLIA.
Thanks, Liz.
Thank you, Elizabeth. Welcome, Erin. Tell us a little bit about FDA.
Sure. So, yeah, I'm going to discuss a little bit about how FDA steps into, or sometimes doesn't step in, to regulate the test itself. So FDA has been regulating medical devices for several decades now. And under the definition of what FDA considers a medical device, all in vitro tests actually fall underneath that umbrella. And so FDA regulates those tests as medical devices. And FDA regulates both tests that are ordered from and performed at home, for example, direct access tests, and those that are ordered from and performed in a healthcare setting or a laboratory, for example, laboratory developed tests. But all in vitro diagnostic tests don't follow the same pre-market path and don't receive the same level of scrutiny from FDA. And I'm going to focus primarily on direct access tests and laboratory developed tests. And I'll talk a little bit about the spectrum of pre-market processes that these in vitro tests are subject to from an FDA perspective. Just in general, when reviewing in vitro tests, the FDA assesses three main points. The first is analytical validity, so whether a test can accurately and reliably measure what it claims to measure. So, for example, is this vitamin K test measuring what it says is measuring in an accurate and reliable manner? And the second point that FDA considers is clinical validity. That is, whether the measurement is predictive of a certain state of health. So does the test accurately predict a particular health state? And can we rely on that measurement to tell us something in a meaningful way about the patient's health or disease state? And last, FDA reviews any claims. So what is the company or lab saying about its test and how well it works? And this claims review is something that FDA undertakes with all of its industries, all the industries under its umbrella. And FDA is really concerned with the information given to a patient and that the impact that information may have on a patient's decision-making process, particularly when it comes to making health or medical care related decisions. And along these lines, if the in vitro test is one that's marketed directly to a patient and is not touched by a healthcare provider at any point, the FDA also looks at whether the test offers accurate descriptive information that can be easily understood by a consumer without the involvement of a doctor or clinician. And FDA will give close scrutiny to the language provided with the test for instructing a user on how to collect a sample and how to interpret the test results. So on that note, direct access tests are a type of, as Liz mentioned before, it's a type of test that is marketed directly to consumers without the involvement of a healthcare provider. And these tests generally request the consumer collect a specimen and then send that back to the company or lab for testing and analysis. As I mentioned before, there is this spectrum of FDA pre-market regulation that all in vitro diagnostic tests fall on. And direct access tests typically must pass a higher regulatory bar than laboratory developed tests and must demonstrate that they clearly and safely relay information to consumers in the absence of a medical professional. And the reason that FDA requires this higher level of review for direct-to-consumer tests is something that I've alluded to already, that direct access tests do not provide a quote-unquote informed intermediary, such as a physician or another trained expert, to explain the results to the patient, reduce stress, and discuss any follow-up options, while physician-delivered reports, such as from laboratory-developed tests, do. And the amount of FDA review and the level of pre-market requirements for direct access tests depend on the particular nature of the test. So what is it exactly testing for? The specific regulatory requirements depend on the risk classification of the individual test. And FDA classifies medical devices and in vitro tests into one of three classes according to the level of regulatory control it believes is necessary to reasonably assure safety and effectiveness. And then, in turn, the classification determines the appropriate pre-market process for that test. And I'm not going to go into the specific regulatory requirements for each of the classes defined by FDA, but I will just generally say that on the one end, we have Class 3 devices or tests that are the highest risk, and those must obtain what's called pre-market approval from FDA. Somewhere in the middle, we have tests that are moderate risk to the patient, and those typically must go through what's called a 510(k) pre-market notification process. And then, and those are typically Class 2, sometimes Class 1 devices and tests. And on the opposite end of the spectrum, we have the lowest risk, and those are typically Class 1 tests and devices. And some of these tests may be exempt from pre-market review altogether. In fact, there's something on the order of like 90% of Class 1 devices are exempt from the regulatory process. So depending on which one of those classes the in vitro test belongs, it may or may not require pre-market review from the FDA. In general, a direct access test for something like a non-medical or general wellness or low-risk medical purpose will not be reviewed by FDA before it can come to market. And then, but a test for a moderate to high-risk medical purpose, such as a cancer predisposition test or a pharmacogenetics test, which will certainly have a higher impact on medical care, will be reviewed by the FDA to determine the validity of the test claims. And tests which provide results that are diagnostic in nature are given more scrutiny by the FDA. So, as I said at the outset, all in vitro diagnostic tests are subject to FDA regulation as medical devices. But I also mentioned that laboratory developed tests typically are not reviewed by the FDA or are given less scrutiny by the FDA. And the reason is that while laboratory developed tests are subject to FDA regulation, they have historically not been reviewed by FDA as a matter of policy. And the thought is that by FDA was that laboratory developed tests were considered relatively simple lab tests that were available on a very localized and limited basis. And if you recall, laboratory developed tests are a type of in vitro diagnostic test that's ordered by a physician, developed by and performed in a single laboratory, is not sold to other laboratories, and is not directly marketed to consumers. But now we're seeing that some labs are developing much more complex laboratory developed tests that have a nationwide reach and present much higher risks to patients or users, such as tests for detecting the risk of breast cancer and Alzheimer's disease. And it's important to note here that diagnostic devices and tests that are designed or manufactured completely or partly outside of the lab that offers and uses that test are not going to be considered laboratory developed tests by the FDA, and therefore will not be subject to FDA's policy of not reviewing those tests before they come to market. So sort of a dichotomy has arisen where on the one hand you have laboratory developed tests that have received no review by FDA, and therefore their analytical and clinical validity are not necessarily assured by the FDA. And on the other hand, you have commercially developed and traditional in vitro diagnostic tests that are sold generally in the market, which have undergone pre-market review by FDA. But we're now seeing that we have these more traditional FDA-reviewed in vitro diagnostic tests and laboratory developed tests that are offering or purporting to offer the same test and are purporting to provide the same results. So even with the involvement of a physician, which a laboratory developed test offers, the FDA has become increasingly concerned about laboratory developed tests and their oversight. About 10 years ago, FDA really sort of began to dig in on LDTs and identified some problems with high-risk LDTs, for example, some that were making claims without adequately supported evidence, those that lacked appropriate controls and were therefore giving erroneous results, and even some that were outright falsifying data. And what FDA was particularly worried about here was that patients could initiate unnecessary treatment or forgo or delay necessary treatment for a health condition altogether based on inaccurate or false test results or even accurate measurements with an invalid claim regarding the test results relationship to a disease. So really over the last 10 years, FDA has grappled with how to deal with this uptick in complexity of laboratory developed tests and how they should be overseeing these tests or regulating them more stringently. So in 2014, the FDA issued some draft guidances on LDTs and proposed a draft approach to how they would be reviewed. And there was a very interesting interplay between whether or not FDA should take complete control over reviewing them, whether the CMS should take complete control over reviewing them, or whether it should be some combination of both. And unfortunately, FDA did not come to a decision on how it was going to move forward. In response to the feedback it received from those draft guidances and some other public meetings it held in 2017, FDA came out and said it was not going to issue a final guidance on the oversight of LDTs. And basically instead it punted and called on Congress to develop a legislative solution. So where we are right now, it's still sort of in this gray area of how much review, how much attention is the FDA going to give to traditional LDTs. But what I can say is that, I would recommend that labs take the concerns that FDA raised initially to heart. And that is validate your LDTs for accuracy and reliability, validate your claims, and generally manage your lab operations in a high quality and professional manner. And with that, I will turn it back to Liz.
Thanks, Erin. And I'll just stop for a minute for a quick time check. Then the final topic that we were going to hit on was a little bit about fraud, waste, and abuse laws, or sort of the overarching federal framework with respect to kickback, anti-kickback, Stark, false claims at a really high level. And that's partially because and I guess what I would say, before we jump into it, knowing that we're sensitive to kind of the timing that we have, and we want to reserve some time for questions. Typically, the federal regulatory framework, when you think about the anti-kickback statute, the Stark law, which is the prohibition on self-referral by physicians, the False Claims Act, which is, submitting a claim that is incorrect or for services that had not been performed, or a claim for something that is going to be reimbursed at a level higher than what was actually performed. All of those laws require government program reimbursement. So if you're operating completely outside of that framework, then these aren't things that necessarily you need to put at the top of your priority list. EKRA, which is the Eliminating Kickbacks and Recovery Act of 2018, it's a little bit more expansive. It has a specific history that related to the opioid epidemic, and so labs were sort of put in the framework along with clinical treatment facilities and recovery homes, and that actually does apply to commercial work. So it's similar to the anti-kickback statute, or the kickback prohibition, which says that you can't essentially pay for or do something to influence or induce referrals that are reimbursed by a government program or a commercial payer. So it's a little bit more expansive. But in all of these instances that I'm talking about, you have to have a payer of some type, whether it's a government payer or a commercial payer. And I think a lot of, or at least, how we kind of envision this is we're talking about, situations where this is sort of cash pay by the individual. But the reason that I think it's still relevant to be familiar with these frameworks is because many states have equivalent laws. They have a kickback equivalent at the state level. They may have a prohibition on self-referrals by ordering clinicians. They may also have, an equivalent to the False Claims Act, meaning, if you billed us, that's more on the Medicaid side, I guess I would say. But, if you billed us for something that wasn't appropriate, we want the money back. And, there may be a penalty involved as well. And so it's really important to be familiar with your state. And it's also important to be familiar with sort of the basic concepts of the regulatory framework with respect to fraud and abuse laws, because there may very well be a state requirement or a state prohibition that you are still subject to, even if you're operating outside of kind of the federal regulation, which contemplates primarily government reimbursement, and for EKRA, it also includes commercial reimbursement. So I know we're at 140, and I just want to stop and ask John and Allison if you think it's worth jumping into these a little bit more, or I think it might be sufficient to just kind of stop and open it up for questions for a couple minutes, because we've kind of run out of our speaking time. But we're happy to stick around for questions. Sure. And I can certainly go on if that's helpful. So.
Yeah, I think that is helpful, and I appreciate both of you, Elizabeth and Aaron, on everything you've been able to present so far. And I will kind of ask the group, you do have that chat function there. If you have a specific question, we'd be happy to make an attempt at fielding that. And when I say specific, probably not too specific, down to any really important details, but big picture type questions, structural questions. Feel free to ask those here. If it's something more detailed than that, we'd encourage you to reach out to. Okay, yeah. So Vasile's saying there's a few questions that have come in through Q&A. We are a POL from Brenda, and we'd like to service patients outside of our group practice. Do you have any advice or suggestions in this area?
Aaron, sure. So
I think, try that?
Yeah, this is Liz. So I'm just kind of navigating myself back to that question. It seems to me like if it's a physician-owned lab, I don't know if we're actually asking about direct access testing or consumer-initiated testing, or if we're just talking generally about a physician office lab. You all, as you probably know well, Brenda, are subject to the Stark Law framework, and under Medicare, what we've done is we've worked with clients before and their MACs in a particular jurisdiction to figure out if it's possible for them to get a separate NPI, not the NPI associated with the physician office lab, but one that would be associated or would be an independent laboratory NPI. And then that would be the way that you would kind of go about billing if you were going to go there. But there's been, I will say, in the work that we've done with clients, there's some conflicting answers and responses that come back from CMS and from the MACs in a particular jurisdiction that are the Medicare administrative contractors. And you also have to consider, you have to make sure that when you do structure it, that it's still consistent with the Stark group practice exception and the in-office ancillary exception. So I know I didn't really answer your question, but what I would say to you is there are a number of different frameworks that you kind of have to work through to, get to a position where you want to do that. So there's a little bit of work and footwork and homework on that. So.
Yeah, I would say don't jump into it without giving it some thought, because it certainly is not a clear, simple solution. You gotta think that through. There's some gymnastics that need to be performed if it at all is compliant. We also have a question from Christina. She wants to know, how do I know if my state allows me to do direct access testing? I would think, Christina, I know Liz and Aaron, that I spoke to Rick over there at McDonald Hopkins, and you guys had compiled a state-by-state survey of that. And so I think the best thing to do would be for Christina to probably reach out to you guys to talk about engaging you to do a review of her state and provide guidance on whether they can offer it or not. And so I put onto the screen a way to get in contact with McDonald Hopkins if you're interested, but I don't know if you guys had anything to add on that, Aaron or Elizabeth.
Yeah, sure, John, thanks. And part of the reason, just to kind of clarify, the reason I'm fielding a lot of these questions, this is Liz or Elizabeth, is because my practice is more on the regulatory side, and Aaron's is more on the intellectual property side. And so we'll split up questions that way. But sure. What I would say is from a lab framework, a state framework, I mean, the places that you would want to look if you were going to do some independent research would be if your state has lab-specific statutes or an administrative code or regulations, you'd want to look there to see if you've got guidance. You may also need to look in the Professional Practice Acts to see if certain professions like physicians, advanced practice nurses, whomever, chiropractors, podiatrists are permitted to order testing and it's exclusive to them. And then certainly reaching out to a law firm to kind of help you walk through that. Those would be the ways that you could go about it. You can always call your state as well, like the Department of Health or whomever manages laboratories. But it is one of those things that you kind of have to look in a couple different places, bring all that information together, and then make a decision. So,
great. We also have a question from Agnes. She's wondering, for direct access testing, is this limited to primary, secondary, or tertiary? Like, does it fall into one of those buckets in terms of prevention of disease? And so I don't know if you want to try to tackle that, but are you allowed to offer direct access testing for primary, secondary, or tertiary prevention of disease? What's her question?
Yeah, so this is going to be such a lawyer question, Agnes, or rather a lawyer answer, I will say. I would say that if it's for prevention of disease, I guess I'd want to talk to you a little bit more about what you're thinking or kind of what you're using for purposes of defining those phrases. But the first thing I would say is it depends. It depends on the jurisdiction. It depends on the state, and sort of what is permitted in the state and what is not. But I would say as a general rule, if it's a more sensitive test and it's actually giving, if it's something that the patient could make medical decisions on and it's not sort of like just a wellness test, then presumably whatever regulatory framework you're working within at a state level, or otherwise if we're talking, CLIA or FDA, if a patient can make, if an individual, whether patient or consumer, can make decisions off that, like healthcare decisions, it's probably going to fall into the bucket of this. It can't just be offered directly to that individual.
All right. We also have a EKRA question. They're asking us to put the EKRA slide up, which I think we have up now.
Yes.
But just wondering, what are the restrictions on compensation? So I guess they're looking for a little bit more on the application side. How does this affect my sales force? Can you guys touch on that?
Oh, sure. I can talk a little bit about that. It's a challenge, I will say. I don't have a good answer because we don't have great clarity. I mean, at the end of the day, the EKRA framework is on the books, and it just doesn't permit variable compensation for individuals, like sales individuals that are out there obtaining business. I should say there's no safe harbor for it. And depending on how you do the variable compensation, if it's a traditional commission model, that is generally, it's our feeling as a group that would not be permissible under EKRA. I've been to some very interesting conversations with a lot of really knowledgeable attorneys from other firms, and I've seen them disagree on this. So there are some attorneys out there that feel that they can kind of pick apart the language as it is and, make some arguments around there. But I think from a conservative standpoint, variable compensation that is related, it's sort of on that traditional commission basis, would be problematic under EKRA. Now, that said, it's also a bit of a judgment call. I would say for most of 2019, a lot of labs out there were sort of taking the wait and see approach with their commission structures or their compensation structures, waiting to see if there would be clarification, because it was sort of the feeling generally of the industry that Congress they didn't really realize what they did when they passed that language and how it would impact the laboratory industry as a whole, not just specifically toxicology labs or labs that were doing testing for, recovery centers and such. So my answer is that really a lot of labs are still in the wait and see phase, but, we're over a year past, almost 18 months past when that language was enacted or became effective. So it's kind of tough to continue the wait and see approach. I've heard of industry stakeholders that are actively pursuing either a legislative fix that would pull through the anti-kickback bona fide employee safe harbor, or would, somehow otherwise clarify or rectify the situation. But as of yet, we really haven't seen anything come out on that. So it's a really tough situation. If somebody wants to be very conservative, then they need to restructure their comp for their sales reps. If somebody wants to kind of be in the middle, then you can sort of build in other things and sort of take that direct correlation out of the compensation structure. And for everyone, what we would say is if you've got 1099, if you still got 1099 sales reps that you're paying on a commission basis, if nothing else, bring them in as employees, true bona fide employees. So if nothing else, you're at least complying with the anti-kickback safe harbor for bona fide employees. But even that, is right now it's not a guarantee. We've heard that the government is unlikely to enforce a lot with EKRA right now because, it's still sort of in flux. And so for AUSAs, the DOJ, OIG that might be using it, they wouldn't want to use it because it's still up in the air a little bit and it could be changed. So they might not want to build sort of an investigation or case around it. But not too long ago, probably last month, was the first time that someone was indicted, and it included EKRA. So I don't know that even holds water at this point. I think people just have to be really cautious, and if you're questioning it, then it's worth getting in touch with your counsel and talking with them about what you think you're comfortable with from a risk perspective. So.
Yeah, I think there's a lot of individuals waiting to hear on EKRA. I think that last case that dropped, was it a month ago, was probably not real helpful to most.
No.
I think it's that it would seem like that was illegal before EKRA and would still remain so. But yeah, so we did a quick poll. I'm just going to call attention to, if you haven't checked out the polls, there's some good information there from you and your peers. And to reinforce what Liz was saying, of the labs that are out there, 26 of the labs that responded, 11 of them, 42%, have revamped their compensation because of EKRA. 27% are still waiting, and 31% were already compliant. And so I'll hit on some of these other polls real quick because I think there's some good data here. Should the FDA provide oversight over LDTs? Majority, just a hair over majority, 51% of you feel like the FDA should oversee LDTs, which I found surprising since usually most people are not looking for more oversight from the government, but you guys felt, the majority of you, that they should oversee it, and it's probably because you're competing with labs that are maybe doing things not quite right. And so if you are a lab that does things in a quality manner, I imagine that would probably be a benefit to you. We also asked, does your lab perform LDTs? Do you have that in-house? And 54% of you have, so a little bit of a majority, have LDTs in-house. 46% are only doing IVDs. Does your lab take samples from other states? At about 23% of you can take samples from all 50 states. 45% can take it from more than a few that require licensure, and 32% of you do not take it from any states that require licensure. Do you want to offer direct-to-consumer testing or offer some of your lab menu to consumers directly? And 50% of you do not yet, but would like to. 19% of you are already doing it. And then 17% said maybe someday, and 14% said no plans to do it. They're going to stick with the old model. So there's just some interesting information there. I think that touched on one of the other questions, and I can maybe field this on the state of New York, but I might leverage your help, Liz, on what do you need to do to receive a sample from the state of New York is the question. So I put up a list. Here's a map of states. This is according to John Harrell and Lighthouse, not McDonald Hopkins, so don't hold it against them if it's wrong. This is just, I'm not a lawyer, so disclaimed, but my knowledge from firsthand experience is states that require it. And I know that your lab director for sure needs to hold a certificate of qualification from the state of New York in the subspecialty that you're offering. And then I believe you also need a facility license from the state of New York in order to do that. I think we're seeing that process take about 18 months. So if your lab's not taking samples from New York right now but would like to, we do offer that service and have a flat fee for it. It could help if you did want to get licensed, or if you need a New York licensed lab director, we can provide that. We provide medical lab directors at Lighthouse to 175 high complexity CLIA labs around the country, including New York licensed or CQ'd directors. But Liz, anything to add on that? If you're a lab in Texas and you want to take a sample from New York, what are some things that you might need to consider there?
Yeah, actually, John, what I would say is I think you answered it really well. You covered the bases. So it's not only that the lab needs a license, but the medical director does as well. And I think you're right. It's a pretty in-depth process to go through it. And I think your out-of-state licensure chart looks really great. I think you're right about Nevada. And the only thing I'd probably add is my experience has been that New Jersey also requires a collection station in the state. If you're going to have, an out-of-state license if you're going to have a collection station in the state. So
yeah, I caught that and put a note down to research that after. That's really helpful. Another map to throw up here is states that do not recognize moderate complexity, and I'll talk about the ramifications of that. So hopefully I caught them. These are ones that we've at least run into firsthand that do not recognize moderate complexity. And so what that means is, even if you're doing an FDA-approved IVD in that state, you're going to automatically fall underneath the CLIA regs for high complexity, because these states don't recognize moderate. And so that means your lab director needs to meet high complexity, needs to be an MD or a PhD. You're going to need the 5 roles that CLIA requires, which is you're going to need a clinical consultant, you're going to need a medical lab director, you're going to need a technical supervisor, you're going to need a general supervisor, and you're going to need testing personnel. So you're going to have to check those 5 boxes, even offering moderate testing, whereas most states, if you're offering moderate, you can get away with testing personnel, general supervisor, a technical consultant, which is a lower level in the lab director requirements, could be a bachelor's degree person instead of an MD or a PhD. So be aware of that as you consider offering testing in these states. States that require licensure for the scientist, so this is a staff level licensure. And so I put a map up here of states that require it. California is going through a really critical shortage right now as a result of the requirement that they have. Theirs is probably the strictest. CLEP in New York's no easy one either, but California and New York are difficult. There is some reciprocity between some of these, but be aware that if you are a medical lab scientist, you're going to need to get licensed by the state in order to perform your job in the states in blue. Or if you own a lab in these states, everyone you hire needs to hold a license to do the work that they're doing. So hopefully I caught everything on this map for those. We can help at Lighthouse. We do have a database of 170,000 medical laboratory scientists and lab professionals from phlebotomists up to pathologists. So let us know if you're having a hard time finding people. We place a lot of people in these states due to the scarcity caused by the state licensure requirements, and we can help navigate that. We do have a map on Lighthouse's website under our resources section that has the application for every one of these. So we've gone to the Department of Health for every state and got those applications and put them all in one spot, so it's easy for you to apply or for you to provide to your staff if you do have an applicant that doesn't have it and wants to apply. And so I think that's basically it. I want to thank UDoTest again. Allison, I don't know if you had anything further that you wanted to add, but I would recommend please check out Allison's website. If you want more information about UDoTest, you can click on the button here. I think this is the future, to be able to offer your testing directly to consumers. So between working with Allison on the software side to facilitate that, McDonald Hopkins to give you some guidance on the regulatory side, and then at Lighthouse, we would love to help with the physician too. So we have built a network of MDs in all 50 states plus DC and Puerto Rico that can order lab tests. So if you wanted to go towards consumer-initiated, physician-guided testing, we can help with that. I'd love to talk to you about it. But Allison software is what we use to do that. It's the best one out there. Allison, anything further that you wanted to say to the group?
No, that's perfect, John. Thank you so much. Yeah, we're really happy with the outcome here. Thank you, Liz and Aaron, and everybody. There were a ton of questions, so we will more than likely be scheduling another webinar, and certainly we'll be getting back to you on your questions individually. Thank you so much.
Yes, thank you, Liz. Thank you, Aaron. Really helpful, great information. And then we do keep this free, guys. We know that most of the other webinars out there in the industry for these topics charge, $150 plus for this. We're giving it free. The way that we're able to do that is we'd encourage you to check out McDonald Hopkins, check out UDoTest, go out to these groups and support them. That's how we're able to continue to offer this as a free service. Thank you, everybody.
Thanks, guys.
All right.
Cheers.
Thanks
All right.
so much. Take care.
Bye-bye.
Bye-bye.
Thank you.